The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones. I'm a Wisconsin family law attorney with O'Flaherty Law, and today we're doing a how-to video regarding Wisconsin Circuit Court Form ME-903. It's the petition for examination. Just to get this out of the way at the beginning, this video is for educational purposes only. It is not meant to be, nor should it be taken for an alternative to legal advice. And this form is going to be a little bit different. This is more of an explanation as opposed to a how-to. You do need to have completed the screening process with the County Corporation Counsel and the county that the subject resides in prior to this form being filled out, and most of it will probably be filled out for you. However, I think it's helpful for you to understand what the form is and how it all comes together because, again, this is a petition for examination. Another way to say this is that this is a petition to have someone committed. So let's go ahead and go through the document so you understand what everything in it is. And with the understanding that the document would be drafted by the County Corporation Counsel in the county where the subject resides. So starting at the top of the form, you'll just see a space for whatever county. You'll be filing in the county where the subject resides. Top right-hand corner, that is the space for the clerk of courts. Nothing needs to be put there that isn't put there by the clerk of courts. There probably won't be a case number when this is filled out. One will be assigned when the petition is filed. Then we go to the rest of the caption. It says, in the matter of the condition of, and then it names the subject and their date of birth. So typically you see this with a family member or a close friend. They've been acting really strange. You think they're a danger to themselves. This goes above and beyond maybe just having a bad day, a clear pattern of behavior where they continually demonstrate that they are unable to make proper choices, would be one way to put it. You would contact the county and begin the screening process to start this petition going. And you'll see here in this box, this document was drafted by blank, County Corporation Counsel, as required by law. So you're not going to be filling this out. You're going to be working with the County Corporation Counsel to get this form filled out, but it is important that you know what this form does. And you will be a part of it, as you will see as we move through the document. So this is a sworn statement, so this is under oath, which means at the end of the document, a signature will have to be done in front of a notary. But let's just go through the language of the document. Under oath, we petition the court to examine the condition of the subject who resides in county and then address, and allege that A, the subject is mentally ill, drug dependent, or developmentally disabled, and a proper subject for treatment because. Now, the form is probably not giving you enough room, or the County Corporation Counsel enough room, to fully explain the situation. So you would probably just click See Attached and do an explanation on a separate sheet of paper. These forms are very specific. They're formatted in a very particular way, and they don't want you to alter the form ever. So if you need more room than is given in any of these circuit court forms, you would just write See Attached or check the See Attached box option and then use a separate sheet of paper because you are allowed to supplement the forms to the extent necessary to include all the information you need to include. So we're looking at paragraph A. And again, they're looking for signs of mental illness, drug dependency, developmental disabled, and you're saying this person requires some sort of treatment, depending on whatever their issues are, their challenges. So that's one option for the petition for examination. The other option, and it doesn't have to be one or the other, it could be both. It could be many things going on. A lot of times when people struggle emotionally or mentally, they tend to self-medicate with drugs, that kind of thing, and they can also become dangerous. So that's when we move into paragraph B. So this is chapter 51 of the Wisconsin state statutes. That is the area of Wisconsin law that addresses these kinds of situations and what the requirements are, what the rights of the subject are, what the rights of the petitioners are. And you can Google that. That is public record. It's definitely something you can look at if you're trying to make the decision to ask for this process to be started. But anyway, moving back to paragraph B, the subject is dangerous to himself, herself, or others as defined by section 51.20 sub A or sub 1 sub A 2 of the Wisconsin statutes. And this is where you need to really think very carefully about what you're going to say. Because here's where you say, my belief is based on specific and recent dangerous acts, attempts, threats, omissions, and or statements made by the subject as observed by me or reliably reported to me as stated below. And that's where the section starts with the dangerous behavior. When did it occur? Where did it occur? What happened? So again, this is probably not going to be enough room to get the entire story told. And you can have more than one instance of dangerous behavior. In fact, it would probably be helpful. So you can always just click see attached and lay out chronologically, would be ideal, on separate sheets of paper what happened. What has made you decide that you need to take the step to get the county involved and the County Corporate Counsel involved in asking the court to examine the mental state of the subject? Obviously, you're going to want to be as specific and complete as possible. You're going to want to be as clear as possible, and you're only going to want to say things that you know for sure, because again, this is a sworn document. Only say what you know is true. Don't elaborate. Don't dramatize the facts, in other words. So once you've told about any specific instances where you were observing the subject engaging in just dangerous behavior, you'll move on to paragraph C, and we're looking for witnesses, people who are joining you in this petition. It can be at least 3 other people. If there's more, you can attach it on a separate sheet of paper. But they are looking for people who have personal knowledge of the subject's conduct. And they want their contact information, and they want to know the relationship to the subject. So it's probably going to be family members and close friends, maybe some coworkers. But you're definitely, their information is definitely going to need to be included on this petition, because the court's going to have questions. Then in paragraph D, they have another possibility for you to include, or to be included in the petition. The following petitioner or petitioners does not have personal knowledge of the conduct of the subject, but bases his or her belief on the following. This could be something like, I've never seen anything, but I've heard about this from other people for years. It's been consistent. So this is what I base my belief on. And they even put a section down here. You know, I've never seen subject X do anything, but I've heard all about it after it happened several times from several people, that kind of thing. And they've got room for 2 here, but if you've got more than 2 people who are willing to participate in the petition, you can always put their information on a separate sheet of paper. So now we've gotten through all the possible petitioners. In other words, all the possible people who could be asking the court to examine the subject for possible commitment. And we'll move on to section E. In addition to the petitioners, the following person or persons may testify in support of this petition. So that's kind of a catch-all. Just people with general knowledge. They've heard about this. They know about this. They haven't maybe they haven't experienced it directly, so they're not a petitioner, but they have a general idea of what's going on and they know the subject. They're aware of what's been happening. They can provide some kind of information or testify to their opinion, perhaps. Paragraph F wants to know the names and post office addresses of any spouse, adult children, parents or guardian, custodian, brothers and sisters, or people who the subject lives with. So they might need to possibly bring some of these people in to talk about the subject, because again, what this petition is asking for is something extremely serious. You're basically asking for that person's liberty to be taken away for a period of time. It could be indefinite, it could be a month, you know, it just depends on the situation. So obviously the court is not going to take just one person's opinion or even 2 or 3 persons' opinion. The court's going to want to get all the possible information it can get from all the possible people who could speak to this person's wellness, to their mental state, maybe even talk about what's been going on in their life. I mean, maybe they don't have a mental illness. Maybe they're just having a really bad 3 months or something. It's just not the kind of thing that they're just going to sign off on it and send somebody into a facility for 3 to 6 months. They're going to do their homework. They want to talk to everyone. And if you're participating in this petition and you have information that's relevant to this section, you need to provide it. And also people need to be notified. They might not know what's going on. This person might have a brother who has no idea that this kind of action is being taken against his brother or sister, and would definitely have something to say about it. And they have the right to do that. So that's all the other interested parties. Obviously, there needs to be more than one petitioner. And ideally, all of you will have to sign it at the same time in front of a notary. So even though the corporate counsel for the county is preparing it, you're still the petitioner. And hopefully you can just meet at the office of the corporate counsel and everybody just sign it in front of one notary at the same time. That would be something you would work out with them. But that is the Wisconsin Petition for Examination. It's Form ME-903. And again, don't modify the form. This is less of an issue because you'll be doing it in conjunction with the County Corporate Counsel. But that is how you would begin the process to have the court examine a subject for possibly being a danger to themselves or others. So I want to thank you so much for watching. If you have any questions or comments, you can go ahead and leave them below, and remember to check back on our channel regularly. We do post new legal content almost every day, and we wish you the very best of luck with your legal matters. Thank you so much.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience, and we serve all of Wisconsin. Thanks again for watching.